This is the first video of a forthcoming series on Texas employment law and the practical effects on both the employee and the employer. Today, we will be providing a general overview of employment contracts. Hi, my name is Spencer Young, and I'm the Senior Associate Attorney here at the Saul Lee Law Firm. Before we move on, it's important to note that any information set forth in this video is not to be considered legal advice. The purpose of this video is simply to provide information that you, as an employer or an employee, may use in your interest to protect yourself. Employment contracts are extremely important because they govern the relationship between the employer and the employee. In fact, they can even go as far as to govern the rights of the parties after the termination or severance of that employee relationship. For example, on the employee side, an employee may sign an employment contract without knowledge of its contents, thus legally binding themselves to certain unknown or misunderstood obligations and requirements. On the employer side, use of vague boilerplate language in an employment contract can render that contract unenforceable and thus, for all intents and purposes, useless. As an initial matter, an individual may act as either a W-2 employee or an independent contractor. In most circumstances, an individual cannot act as both an independent contractor and an employee at the same time. The remainder of this video will focus on W-2 employees rather than independent contractors. Texas is an at-will employment state. Now this means that the employment relationship can be ended by any party at any time for any reason, so long as those reasons are lawful. Examples of unlawful reasons for termination can include discrimination related to age, race, sex, culture, or the like. This gives both the employer and the employee the freedom to choose where they work and who they work for. Contract is not necessarily required to create an employment relationship. It may still be a vital part of that employment relationship. Employment contracts have the ability to affect the rights and the obligations of the parties, specifically what these parties can and cannot do. While the employers are the individuals who are actually drafting the terms of the contracts, employers are nevertheless bound by certain guidelines. For example, the employment contracts must be valid and enforceable, they must be for a legal purpose, and they must comply with all federal and state law, regulations, and guidelines, such as FLSA standards, child labor laws, and discrimination. As a side note, if an employer suggests entering into an employment contract, this contract should always be in writing. In any legal case relating to a contract or the breach thereof, one of the first questions that your lawyer will ask is whether or not there is a written contract. While in some cases, contracts can be created through oral agreements, these oral contracts are much harder to prove in a court of law. There is no evidence of what these specific terms are. Thus, whenever a party moves to enforce said oral contract, it turns into often a he said, she said situation. The lack of a written contract is one of the biggest issues that is faced in these type of matters.